Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you to the roadside chat from the studio. All right, this question comes from an officer in California. All right, so let me just kind of give you the question basically is, will a no trespassing sign and a closed gate prohibit you from doing a knock and talk? All right, so before I kind of go into my feedback here, let me give you some context here. So deputies in a rural setting, they want to do a knock and talk on a burglary suspect. They don't have probable cause to arrest him. Now the suspect lives on a 100-acre ranch. It's fenced, barbed wire. The driveway gate is closed, but also to keep the cows in, right? It's a ranch, it's a working ranch, but the gate is not locked. There are several no trespassing signs provided near the front gate. About midday, the deputies open the gate, drive through, and close the gate behind them. Don't let the animals out, right? They drive down a mile-long driveway to reach the suspect's house, and they talk to him. So the officer has two questions. Number one is, are we good here on a knock and talk? And number two is, if we are or we're not, if we develop probable cause to arrest him, can we arrest him? Okay, so whether or not a knock and talk is lawful falls under the Girl Scout rule. Okay, it comes from a case called Florida versus Jardines, U.S. Supreme Court. So the Girl Scout rule basically means this: do you believe, take the cop part out of it, right? I know your mission is to find evidence, but take the cop part out of it. Do you believe that the Girl Scouts could do the same thing without offending this person's reasonable expectation of privacy, right? Or trespassing on his property? Do you believe that he would expect or understand that some people want to go to the ranch and try to sell him cookies? Do you believe that those no trespassing signs, and in the other context here, do you believe that a politician looking for votes wouldn't feel comfortable going up to the gate? Context matters too, in the sense of where this guy is. He's on a 100-acre ranch. Of course, he's supposed to have gates and fences. We also, it's very common to put, barbed wire up and so forth, razor wire up around people's property because people steal stuff, right? It's remote. The no trespassing signs, that makes sense. I don't want you on my property for, illicit purposes. Now, the Ninth Circuit, you can, for those people that live in the Ninth Circuit, or I'm sorry, work in the Ninth Circuit, right? For my cops, they know that the Ninth Circuit is a little tougher than most circuits. And even the cops in New York City know the reputation of the Ninth Circuit. They have a case that does talk about closed gates and no trespassing signs near the front gate. And that basically they held that gave you a signal that you could not do a knock and talk. That was not one of these ranch cases. That's where the no trespassing sign was right at like the front of the yard and the closed gate. I've always been suspicious of that case to begin with, because a lot of people put no trespassing signs up just because that's just, it's routine to do that, especially on farms. I'm sure you see a bunch of other no trespassing signs on other people's farms. It's just kind of it almost comes with the property. This can go either way. Your judge is going to matter on this one. I'm going to lean towards it's lawful. The knock and talk is lawful. Because I don't see that, that because the gate's unlocked and so forth, and we have a reason for the gate, it just makes sense. I don't think that the Girl Scouts are trespassing on this person's property just with those other factors, and it makes sense that he has these things up in place. However, there are reasonable minds that can differ with me. So that's my first thing. Now, the officer also mentions, look, we don't have this is open fields, and it certainly is. So we don't have a curtilage violation. So wouldn't that, will it really matter if, this fence? And the answer is it does matter, because it still sends a signal to you about whether this person wants to be left alone or not. So even though passing through the gate would not violate the guy's curtilage, because curtilage cannot extend out that far, it's only the area around the home. But again, I think you're okay. I'm going to lean on the side of that this is a lawful knock and talk, especially if it's articulated correctly. Now, the next question he has, okay, let's say they were at the front door. He, apparently this is from a real case that he did speak. If we have probable cause and he's on his porch, can we hook him up? And the answer is yes. That's U.S. versus Santana. He's within his threshold of his doorway or out. He is arrestable under the Fourth Amendment. Now, if he's inside of his home, then he's off limits. You would have to get judicial pre-approval unless you have some form of exigency, imminent escape, legitimate officer safety issue, imminent destruction of evidence, right? That type of stuff. So great question. Again, the Ninth Circuit is a little tricky. So I want to hesitate on giving you a black and white answer on this one. I'm leaning towards yes, but you know why? It can go either way at the same time. All right. So articulation is going to be the key on this one, I believe, about why the general public could do the same thing that you did. I hope you like it. Guys, if you want me to keep doing what I'm doing, hit the like or comment, subscribe, share with your friends. And until next time, my friends, stay safe.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.